Good morning, everybody. In the previous video, we discussed about Article 168, 169, and 170. 168 was the definition of the state legislature, which consists of a legislative assembly and a legislative council, if there is one, and the governor of that state. So, though the governor is not an elected member, yet he is part of the state legislatures. Article 169 was about creation and abolition of state legislative councils, and Article 170 is about readjustment of assembly constituencies in a state and taking up of census and conducting elections. Now let us come to Article 171, which is related to the state legislative councils. Article 171 Clause 1 narrates the composition of a state legislative council. In terms of this proviso, the total membership of a state legislative council shall be to a maximum of 1/3 of the membership of the state legislative assembly. Another condition is that to constitute a legislative council, there must be at least 40 members. So by implication, only such of the states which have at least 120 members in their legislative assemblies can create legislative councils. There are only a few states in India which have legislative councils, like Telangana, Andhra Pradesh, Karnataka, Bihar, Uttar Pradesh, etc. states. And all other states do not have legislative councils. Then coming to the point of how these members of the legislative councils are elected or nominated. It is dealt with in Article 171 Clause 3. It says that 1/3 of the membership of the Legislative Council shall be filled by members of the Legislative Assembly. Another 1/3 of the membership shall be elected by the local bodies, namely MPTCs, ZPTCs, municipal corporation members, etc. And 1/12 are elected by the graduates in that state who have been graduates at least for 3 years before the date of registering electorate for the legislative council elections. Another 1/12 are elected by teachers who are teaching in educational institutions in secondary schools and the above. So there remains 1/6 of the membership. It is to be filled by the governor of that state. While filling such vacancies, the governor shall appoint such of the people who are experts in arts, science, literature, social service, and cooperative movement. This is what the plain text of Article 171 is. When we said 1/3 of the membership is filled by MLAs, 1/3 by local bodies, 1/12 by graduates, and 1/12 by teachers, and 1/6 by the governor of that state, selecting from among those people who are experts in science, art, literature, etc. Unfortunately, everybody is filling up their quota, but unfortunately, the quota of the governor is being filled by the chief minister of that state, under a mistaken notion that the governor shall not do anything on his own and he is bound to act on the advice of the Council of Ministers. Council of Ministers is nothing but the chief minister and his henchmen. Please remember such a condition as the president heeding to the advice of the Council of Ministers is not contained in Indian Constitution. It was only in 1976 through 42nd Constitutional Amendment that Mrs. Indira Gandhi amended Article 74, which is related to Constitution of Union Council of Ministers to aid and advise the President in discharging his functions. That amendment says that the President is bound by the advice of the Council of Ministers. The President may return the advice of the Council of Ministers for a maximum of one time. If the same advice is tendered by the Council of Ministers for the second time, the President of India is bound to act upon it. It is not amendment, it is destruction of the Constitution and democracy as well. In a democracy, there should be separation of powers between the legislative and the executive. If you say that the executive is bound by the advice of the legislative leader, where is democracy? Where is distribution of powers? An important point to consider in this case is that this 42nd amendment is made to the 74th article regarding relationship between the union ministers and the President of India. It is a surprise for me why the same is being followed in the states also, between the State Council of Ministers and the governor of that state. Especially the relationship between the state governor and the State Council of Ministers is defined in Article 163, 164, 166 and 167. Article 163 says that there shall be Council of Ministers to aid and advise the governor in discharging his functions. Article 153 says there shall be governor, he shall be executive power of the state, which may exercise by himself directly or through officers subordinate to him. So, a governor can act on his own in exercising his functions. The ministers shall not be entitled to advise the governor in matters which require his own discretion, and the actions taken by the governor shall not be called in question as to whether he acted on his discretion or based on the advice of the Council of Ministers. That means it is the absolute power of the governor to act either by himself independently on his own or based on the advice of the Council of Ministers. An advice is always an advice, it can never be an order, especially the subordinates who are Council of Ministers cannot pass orders to the governor or against the governor. Article 164 says that the Chief Minister is appointed by the governor and the other ministers are appointed by the governor, and their terms of office shall be during the pleasure of the governor. However, in India, in Indian states, we are seeing whoever has majority in the legislative assembly is becoming the chief minister. This is not proper. When he has the majority, he can pass whatever law he wants, his word becomes law. And if we say that the governor is bound to accept the bills passed by the majority party in the assembly, virtually there is no executive. So it cannot be democracy. The majority can pass draconian laws. He may allocate all state resources to his friends and relatives and others on quid pro quo. He resorts to retribution and oppression on the opposition parties. His party workers resort to rampant corruption and oppression on the opposition parties. This is not democracy. Such a system is contained in Pakistan Constitution under Article 130. But such a system is not contained under any provisions of Indian Constitution. Whatever we are doing as on date is in total ignorance of the constitution and in total ignorance of the basic tenets of democracy. Article 166 says that even if the governor wants to allocate duties to the ministers, he cannot allocate such of the duties which require his own discretion. Article 167 says that it shall be the duty of the chief minister to report to the governor all legislative and executive proposals. By combined reading of these Article 153, 163, 164, 166 and 167, you must understand that the ministers are a very low level subordinates to the governor of that state. Why I am describing all this is that the quota of the governor to fill up the vacancies in the legislative council are being grabbed, taken over by the chief minister. Please understand, appointment of members to the legislative council requires discretion of the governor. He has to find out, he has to decide whether such people are possessing such of the qualifications as required by Article 171, Clause 5. Why these seats should be filled up by the governor is also an important issue for discussion. I told you several times in my previous videos that President of India is necessarily a politician and belonging to a political party. He is elected by the Electoral College consisting of all the MLAs in India and members of both houses of the Parliament without issuing a whip. President of India is the only elected executive under Indian Constitution. He is not bound by the advices of the Council of Ministers. Such a condition is contained in Pakistan Constitution under Article 48, which says that the executive power of Pakistan is vested in the President of Pakistan, but he shall exercise such function with aid and advice of the Council of Ministers, which should consist the Prime Minister. Such a condition is not contained under Indian Constitution but for the 42nd Amendment of 1976. Even if it is amended, it is a ridiculous thing to say that all powers are yours, but you have to act according to my advice. It means that you do not have any power whatsoever except following my advice. Would advices ever become orders, especially by the subordinates to their superiors? It is an insult to language. Even a 10th class student can understand if these conditions are contained or written in any Indian language. The English language is not understood by the elite of this country and they pretend to understand it, or sometimes they may use their English knowledge to deceive the people by giving subtle prevarications, misinterpretations, and misapplication of the constitutional provisions. Coming to the need of a legislative council, we shall discuss it. Any bill has to be passed in the legislative assembly and also the legislative council. When through an election, some political party gains total majority in the legislative assembly, he can pass whatever law he wants, he can loot the state, he can oppress the opposition parties. But when there is a legislative council, the legislative council is not filled up in one single transaction. The members of the legislative council retire by rotation every 2 years. 1/3 of the members retire by rotation every 2 years. That means even if a political party gains total majority in the assembly in a particular election, yet the majority party or its leader cannot pass bills whatever he wants. It has to be passed in the legislative council also. So this is a check from misusing the majority. So it is necessary that there should be a council of State Legislative Council. And I explained several times that president was a political person. If an NDA president is elected, there will be NDA governments throughout the country, including all states and union territories. If a UPA president is elected, there will be UPA governments throughout the country. Then there would not be clashes, disputes between state and the state, state and center, and there won't be dissolution of legislatures midterm, and there will not be midterm elections. The country will be peaceful and prosperous for 5 years. So when a bill is passed by a majority party in the assembly, that is the stand of that political party. Whereas the governor belongs to the political party of the President of India. Not only the governor and ministers should belong to the same political party. At the union level, the President and union ministers belong to the same political party. So the majority party takes a stand in the assembly and the governor takes his own stand as stand of his political party. If a wrong bill is passed for the second time and sent to the governor and he is obliged to assent to such bills, the party of the governor, rather the party of the president, will have to go to masses and explain that such and such party, using its brute force, has passed a malicious bill which is deleterious to the state and the people. And the other condition is that the governor has withheld the bill. Unfortunately, the Supreme Court recently held that governor has no option of withholding the bills. So that is a death blow to the democracy, that judgment. Because withholding of that bill is the prerogative or the stand of the political party of the president represented by the governor of that state. In such case, the opposition parties who have majority in the legislatures will have to go to masses and explain that they have formulated a beautiful bill, passed it in the legislatures, but the governor is standing a stumbling block and has withheld his assent to the bill. Ultimately, it is the people to decide whether the majority legislative party is right or the party of the governor is right in withholding the bill. That is the beauty of democracy. Instead, judiciary is taking over the rights of the people, the ruling party and the opposition party, and is becoming everything in itself. Coming to the question, why a president of India or a state governor withholds a bill, which is the stand of their political party. Recollect the oaths of office of President of India under Article 60 and that of the governor of the state under Article 159. They take oath to preserve, protect and defend the Constitution of India and the law to the best of their ability and to devote themselves for the service and well-being of the people of India. Now consider, if a bill is passed by the majority party in the legislatures, which is against the constitution, which is against the established law, which is against the welfare of the people of this country, should the president and governors should assent to such bills? A state legislature may pass a bill for separation of their state from the union. They do not want to continue as member of this Indian Union. Should the governor pass such bills? If a bill is against the constitution, against the law, against the welfare of the citizens of India, the executive, namely the president and the governors, are bound to withhold their assent, recollecting their oaths of office under Article 60 and 159. Thank you. Thank you for watching my videos. I request you to please subscribe, share and comment on my videos. I informed you I started this web series to bring to the notice of the listeners the conflicting provisions of the Constitution due to misunderstanding of which there is political instability, political uncertainty, and political immorality in India, and there is social strife and abnormal poverty. This is all due to misunderstanding, misapplication, and misuse and misinterpretation of the Indian Constitution, which is not only the largest written constitution in the world, but also one of the best constitution in the world. Thank you.